The time now is 10 minutes past 6. Thank you so much for being patient if you're one of those people that came in at 6 p.m. Hello and welcome to this edition of the Music Business Education Series. My name is Thoko Kadewere and I will be your host today. I'm supported by Bokani Gaunda, also known as Kim of Diamonds, who will be live tweeting and ensuring that what we discuss today makes its way over to our social media pages. So this Music Business Education Series is an initiative by Vwaza Multimedia in partnership with the Diamond Standard. It was created to help artists in Malawi and the African continent at large learn and understand music as a business so that they can move from practicing music as a hobby and have it turn into something that generates revenue for them. Now, today we will be discussing the topic of intellectual property rights. And if you've been in the music industry or the arts industry at large, then this is a term that you've come across at some point. You may know that it has something to do with the law, with how artists protect their work, and with how artists make money. However, although you may have this knowledge, understanding the hows, the whats, and the whys may be difficult. That is why today we are joined by Madalo Banda, who has over 8 years of experience working as an intellectual property lawyer, and she works with the Malawi Bar, and she actually has a master's in IP. Okay, she also happens to be the legal advisor at Vwaza Multimedia. Madalo, I'd like to officially welcome you to the program. How are you doing?
Thank you very much for that introduction, Toko. I'm doing very well. How are you?
I'm awesome. Now, I just want you to introduce yourself. Maybe there's some important aspects of your work that I may have missed.
No, you were pretty spot on. As introduced, my name is Madalo Banda. I'm a lawyer here in Malawi. I've been practicing for 8 years, and I have a Master of Laws in Intellectual Property Law, from the University of Cape Town. And
Awesome
yeah.
stuff. Go on. It sounded like you had more.
I am in private practice, so I do not work for Kosoma or any kind of government organization. I am a private practice attorney. But yeah, my specialty is, or my special area of interest is intellectual property law.
Awesome stuff. Now, to the audience, I want to let you know that if you have any questions for Madalo, you can write them in the comment section, or you can hold on to them until we give you the floor to ask them personally, because we will have a comment section for you to ask your questions. Now, let's get right into it. I want us to start with the basics. What exactly is intellectual property law?
Okay, so intellectual property, oh, not exactly intellectual property law, but intellectual property is a right or property right that results from human creativity, right? So think of people who write songs, people who play instruments, people who invent things, people who are authors, poets. So it is a property right or a right that is derived from human creativity. So
Mm.
when you think of intellectual property law, you think of things like patents, you think of copyright, you think of trademarks, you think of all these different rights, depending on what it is that you've created. And what you need to understand is that intellectual property and any rights that are derived from intellectual property, the key point is that there has to be human ingenuity. So, for example, if you get something like ChatGPT to write a song for you, or to help you compose a melody, or whatever it is, you get some sort of robot to do something, or you put a monkey on a keyboard and get it to, play a couple of notes.
Mm.
That thing will not be something that is protected under intellectual property law because it did not result from human creativity and human ingenuity. That's why they tell you, with the emergence of AI, they tell you to be careful with AI because if you use AI to write a song, you have no rights to that song. Whether it's a good song, it's a bad song, you have no rights to that song because you're not the author of that song.
Hmm. That's an interesting aspect that has kind of just taken me away from what I wanted to ask after that. But you've mentioned something interesting that I would like for us to focus on a bit because it's trending right now, and that's the AI aspect. Is there a way right now that the law or maybe just copyright agents are able to tell when something has been created by AI?
Okay. As of right now, because AI is just an emerging area of tech, there aren't really specifically policies that have been put in place to protect, especially in the Malawian context. There haven't been policies that have been implemented to protect artists or to detect kind of AI, something very Malawian specific. There hasn't been anything of that nature. But just to let you know that the law does say it has to be authored by um, a human, it has to be authored by a human being. So for example, the main area of intellectual property that we'll be focusing in our discussions today when it comes to the music business specifically will be copyright. So the idea of copyright is to protect original works of human authorship, so it has to be an original work. So if you use AI to create something, then it means that that work is not made by a human, and it might not be original, because in the way we understand how AI works, they took works from millions of different artists, millions of different creatives. So whatever it is that you're creating is a derivative work of, or it is a work that has been created off of the unpaid labor of artists, actual human artists. So that's why those kinds of works are not protected.
Okay.
Mm.
What does protecting your work look like as an artist, specifically someone that's operating in Malawi? What does it look like getting your work copyrighted?
Okay. So I think we need to go to the very basics of understanding copyright law in Malawi, okay? So copyright law in Malawi is governed by the Copyright Act. So if this is a resource that you're interested in, you can always go online and Google Copyright Act Malawi, and you'll be able to gain an understanding of, or you get a copy of it. The full copy of it is fully digitized, fully available for any interested party. So that's first and foremost, your first point of call. It is a very how do I put it? It's not the easiest read, but you would be able to get through it without any kind of professional background. You can get through it. Secondly, the point of the Copyright Act. The point of the Copyright Act is to protect specific works, right? So it protects literary works. So, for example, books or authors, poets. It also protects songwriters, right? So that's a literary work. It protects dramatic works. It protects musical works, artistic works, audiovisual works, sound recordings, broadcasts. You know, so performers like choreographers, dancers. It protects all of that. So it's all encompassing. So the first question that you need to ask yourself, or the first thing that you need to understand, is at what point do you get a copyright in a particular work? So, for example, if I sit on my desk and I decide, oh, I want to become a songwriter today, I wake up one morning and I decide to write a song, I scribble it in a notebook. Immediately upon creation of that work, you have copyright in that work. You don't have to register it for you to have copyright in a particular work. So at point of creation is when you have a copyright in a particular work. So if I write a book, even but the problem is you now have to prove that you were the first person. So if you haven't distributed it to somebody else, the question then becomes, oh, were you actually the one who authored this work? Were you not the author of the work? So when you register with an entity like, for example, Kosoma, it has a registration date. So for example, I scribble something in my notebook and I keep it under my bed for 2 years. In the next 2 years, I hear a song that sounds suspiciously like my song that I scribbled in my notebook. The question then becomes, who is the actual original author of it? I can simply say, oh, I wrote this in my notebook 2 years ago. Yeah, but did you go and get it registered? If you didn't get it registered, it becomes difficult for you to prove that you are actually the author of that work. That's where entities like Kosoma become important, because they provide you that proof that no, this individual came to us 2 years ago and registered this particular work on such a date. Let's say 1st of November 2025, this song was registered. Where are your registration records? You don't have anything, because you just put it in a notebook and put it under your bed. So that's where the registration point of it comes in. Now, if you're wondering what kind of works can be protected by copyright, maybe you feel like your song isn't good enough. I promise you, copyright is not interested in the quality of your work. Okay, we're not here to critique you. We're not judges. Copyright actors are not there to critique your work. It's not about the quality of your work at all. It is just the fact that your work has been made. That's the point of core of it. Is an original work that has been made by you, and regardless of quality, you have protection under copyright.
All right. I was taking notes for something that you said,
Okay.
that you can pretty much protect your work at any point. And if your work isn't protected, you have the burden of proof. Basically, when someone else creates something that's similar to yours, you then have to prove, to say, okay, this I didn't register it, but it's mine, here's my proof. But then it's going to be an arduous process for you as an artist. I want to understand how copyright applies in instances where there are two artists whose works are registered, but say one song sounds, like you said, suspiciously similar to another song. I don't want to name drop, but there was something earlier earlier this year, where a very, very popular artist, he's actually a hit maker. He released a string of songs, and then sometime this year, people actually started to make comparisons, like, oh, this beat actually sounds like the beat for this other song. This lyric sounds like the lyric for this other song. How does copyright apply in those instances where something sounds like something else that already exists, but then both works are protected by copyright?
Okay, so let me just clarify the point that I was making at the beginning, to say that just to add on what I had previously said, to say that if you think to yourself, oh, I have this idea of a song, it should go like this, my love, blah 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 blah, but you don't actually write it down, you don't actually record it, you just have the idea in your mind. If you hear something in the future that sounds like your idea, that you have no rights to that, because copyright does not protect your idea. It protects how you express your ideas, right? So it's what is protected is what you write down. If you record it, let's say you've got an idea of a song, even if you don't publish it to the public, you go to the studio, you record that song, you have copyright in that. So I don't want people to think that copyright subsists maybe when the song starts to hit the radio. No, the fact that you've gone to the studio and recorded that song, you have copyright in that song. Whether you haven't gone to Kosoma yet, you still have copyright in that song. Now, there are instances where one artist will create a song that sounds suspiciously like another artist's work. There isn't a specific hard and fast rule of to say that if you have, maybe if it sounds like this, then it's definitely been copied. Obviously, we know that there are laws regarding direct sampling of somebody else's work, right? So, for example, if you use a snippet of somebody else's song in a different song without that original artist's consent, they can take all the royalties to that song. They can sue you for that song. They can get any economic benefit that you get from the second song. From the original author can get economic benefit from that. So one way to alleviate that is to get permission or consent. But the question that you've said is, if there are two songs that sound similar, that's where the courts now come in, right? the one artist plays one song and the other artist plays the other song, and then the court's discretion is used to determine whether or not one song has copied the other. So I'm sure we may have heard in passing of the Marvin Gaye's estate suing Robin Thicke for the song Blurred Lines. People said, some people, lay opinions said that the songs don't sound similar, but the courts found that the songs actually sounded similar enough that Marvin Gaye's estate was granted economic rights in Blurred Lines, and Robin Thicke and Pharrell had to pay out a large sum of money, even though no snippet or no part of Marvin Gaye's song was actually taken into that song. So it's all up to the court's discretion. So that's why it's like the court gets to decide whether or not the song sounds similar enough to give the other author rights to that song. So there isn't a hard or fast rule.
That's interesting. Another thing that I would like for you to clarify is that you mentioned earlier that copyright is something that's there in our constitution, right? Like it's in the Malawi constitution. And in my thinking or my understanding, this means that other countries have their own versions of the copyright law, which may or may not differ from what we have in Malawi. So in the instance that there is a difference in these laws, or maybe that should be the question, are the copyright laws different? Say the copyright law in Malawi, is it different from what's there in South Africa, in Zimbabwe, in the USA, and other countries, number one. And number two, in an instance that these laws are not the same, does this mean that an artist who copyrighted their work in Malawi, do they have those protections, like those copyright protections in other countries as well, or on the global scale? Or do they have to kind of like continue copyrighting their work in all these other countries where their music reaches or where their art reaches?
Okay, so if we're looking at the international scale, there is what we call the Berne Convention. It was an international treaty or an international agreement that was entered into regarding standardization of copyright laws. So, in as much as there might be some slight local differences, but for the most part, most of the important provisions are the same in different jurisdictions because of that Berne Convention. So, for example, just because Beyonce is an American artist doesn't mean that I can now uh, in Malawi record Single Ladies and start distributing it and doing all of that without those rights holders' consent, because at the end of the day, they still have copyright in that work. So it doesn't matter if someone is in Malawi or is in America. Let's say in Malawi we have our own artists. You produce your song, you put it on the radio. That doesn't mean that an American artist has the right to hear your song, copy it, think, oh, that person is just in Malawi. They probably won't, they probably won't do anything about it. And then they decide to record your song. Like let's say Zeze's song is re-recorded by an American artist. Zeze has every right to sue because that's a copyrighted work, despite the fact that they're in different countries or different jurisdictions.
All right, that's good to know. I personally am comforted that there's a legal framework that is recognized on a global scale. I see we have a question. I'll take that one, but then we do have to go back to programming and then we'll take other questions later on. Brigitta, you can ask your question.
Not necessarily a question. I wanted to sort of like give an example on what Mad has explained. I'm pretty sure that other people know about Tyler, the Creator. He's an American-based artist, but he sampled something from Zambia, and he had to credit the people, the original song from where he had taken the inspiration from. So I think it's also like, just because you're in a different country, it doesn't give you a pass to just use other people's items how you want them to, how you'd feel like using them. I do remember early when I was young, I had no idea about copyright things, but I think that is the very first copyright issue I encountered. The late Joseph Tembo stole a song from I don't know if it was from DRC or whatever. The Mbuje song, he literally took the beat, everything, and then just changed like the lyrics. And it was a very big thing for a very long time. That was like intercontinental. The people from here were trying to settle that dispute. So I was just trying to make a comment on what Matt has said, that it doesn't necessarily give you a pass. I think as long as the copyright is attached to a certain thing, even if KFC comes here as a franchise, that you have to, I could maybe relate it to something like that. So yeah, that's the comment I wanted to make.
Thank you for that comment, Richita. Yeah, I do remember that issue. And the song you're talking about was from Botswana. So yeah, it was definitely an interesting time. But then in terms of getting permission, back to you, Madalo, in terms of getting permission as an artist, what does that look like? Is there, say, some sort of framework that says you should do this and this and this? Or is it more an artist to artist or brand to brand type relationship?
That is specifically an artist to artist or brand to brand relationship. That's why it's very important to have a good team around you, because if you've got a good manager or you've got a good understanding about and good relationships with the other artists, you can, or with your record label, if you have if they have a good mutual understanding between the two of them, then it's possible to negotiate very good terms. But it's entirely dependent on your negotiation skills. And it is also up to the other artist to deny you and say, no, I do not want my work to be transformed in any kind of way. We know an artist, a famous artist, who usually refuses to grant other artists rights to her works is Tracy Chapman. you know so she's someone who's very notorious for holding on to her rights and saying, no, I don't want you to transform my work in any way. So that's dependent entirely on the other artist, and you as well, so if somebody wants to rework your work, sample your work, you have every right to say, no, I don't want you to sample my work.
Mm. Are there other examples of I don't know how to frame this, but kind of like what copywriting someone else's work looks like. You've given an example of sampling their work or remaking their work into something different, but kind of taking their work as a baseline of sorts. Are there other types of copywriting that exist, especially in music?
Okay, I want to understand what you're trying to say. Are you asking what kinds of copyrights subsist in a song? What
No,
what you mean?
no, like, okay, you've given an example of sampling,
Mhm.
right? To say that that's a way. I don't know, I don't actually know if copyright is the word to use, but the question is pretty much, what are the other ways that you can borrow someone's work? Or another way to think of it would be to say, what are the ways in which an artist, a musician specifically, could be prone to copyright issues
Okay.
should they get someone else's work without permission? So there's the sampling part, where maybe you listen to a song and you're like, oh, this beat is so nice, I want to do something with the beat. And then you also said remaking someone's work as well. Are there other types of things like that? I don't know what to call them, but
Okay.
instances like that.
I think I'm picking up what you're putting down. You're saying that in what ways can artists work, or in what ways can somebody's copyrights be violated? Is that what you mean?
Yeah, violated or observed, one of the two.
Okay. If I'm understanding your question, let's say, for example, you have a song, right? You have produced your song, you have recorded your song, it's there, it exists, you went to Kosoma, you registered it. If somebody wants to, let's say, play your song on the radio, right, they need to pay royalties to you. If you hear your song being played on the radio and you do not receive any royalties, that means that whatever broadcaster has violated your rights. You are supposed to get money out of that because they're playing your song in a radio. So those are broadcasting rights. If, for example, as a copyright holder, you hear your song being played in a club by a DJ, you are supposed to get royalties from that establishment. If your song is being played at a wedding, you are supposed to get rights from you're supposed to get royalties from that from that DJ who's playing that song. So if it's a situation where you hear another artist, okay, so I need to distinguish the difference between the publication of your work and the infringement of your work. So if your song is being played in a public venue, you're supposed to get royalties. They don't have to ask you specifically for permission, but you're supposed to get royalties from that. So you won't necessarily have NBC asking you directly, can we play your song on the radio? It's just that if it is played on the radio, they're supposed to pay you money. That is not necessarily copyright infringement. Infringement comes in if somebody is claiming to be an author of your work, or they use their work, or they use your work to help their work. So, for example, infringement comes in if another artist samples your work without permission. That is infringement, not a radio station playing your song. That's not infringement. If somebody interpolates your song, let's say they take your beat, try and change it up a little bit, just not trying to make it seem as if it's not the same song, but the actual beat of the song and the meat and bones of your song is essentially the same. That is also a violation of your copyright. If somebody decides and says, oh, I'm gonna quote unquote record a cover of your song, but they're getting economic benefit from that song, then they have also violated your rights in that song. They're not supposed to do that. So there's a difference between, let's say, your work being played publicly by someone who's unauthorized and somebody stealing your actual authorship in that work. Another infringement of copyright is, for example, if somebody decides to take your song from the radio, they burn it onto a CD and start selling those CDs. That is an unlawful duplication of your song, so that amounts to infringement of the copyright. I don't know if that's what you were asking. Was that what you were asking me to clarify?
Yeah. Okay, so you've mentioned all of these spaces that feel so hard to track. Like, I understand that, say in the case of radios and TVs, that they have legal obligations to, say, Kosoma, the MACRA kind of governs that. Correct me if I'm wrong. MACRA governs that and actually says you need to submit to Kosoma your playlist logs and things like that, so that we're able to track whose songs were played, how many times, and how much royalties we should remit to that particular artist. But then in the case of, say, DJs or venues like clubs or even weddings, things like that are hard to track. Are there institutions that do that, like that tracking? Does Kosoma do that? Or maybe there are other bodies that do the tracking of when public venues and all of these event spaces use your music as an artist?
Brilliant question. Okay, so it's Kosoma that governs that. That's why it's important for you to go to Kosoma and register your work and tell them that, okay, this is the author, this is the producer, this is the vocalist, this is whatever. It's important to go and register that song because the rights vest in the actual work itself. But if you're wondering about public places, like let's say a club, they are supposed to get Kosoma licenses. So if there's a public place, let's say there's some kind of establishment and they play music in that place, they are supposed to get a Kosoma license. It is a compulsory license because you are essentially publishing that work to the public. Okay, you have maybe speakers or whatever. Even if you don't have a DJ, you've got speakers there. You're supposed to have a license in order to play that music, and you pay for that license. That's how artists get their royalties, because the money from the royalties comes from those licenses. That's why they're supposed to keep a good log of the songs that they play. It's the venue's responsibility to say that, okay, we played this song, and then they go and they pay for it. Similarly with DJs, what you might not know is that you can't just go and play people's music in public. You can't do that. So if you were putting yourself as a DJ, you are supposed to go to Kosoma and get a license. That's why it's important for you as an artist to understand your rights, because if you go to an establishment, if there's a party, there's a DJ who's playing your music. You can go and cross check with Kosoma and see, okay, there was DJ Mada was playing my song at this XYZ club. I want to cross check if this person has a license. You can go and cross check. If that person doesn't have a license, you report them to Kosoma. And Kosoma there are repercussions to doing that without authorization, because artists are supposed to be paid, and Kosoma takes that seriously.
I'm actually very shocked. I had no idea. Like I always knew about the TVs and the radios and stuff, but then that clubs, for example, need licenses from Kosoma is very new to me.
Exactly.
And that even DJs need licenses.
So, if there's somebody here who has an establishment and you play people's music there, go get your license. Otherwise, there are enforcement officers. They'll come, they'll shut your place down for lack of a Kosoma license, and you have to go and pay fees and penalties. So make sure you go and get your Kosoma license. If you're an artist, make sure you keep your ear to the ground. If your music is being played in particular places, you can go and cross-check with Kosoma to see if the places are licensed, and if they're not licensed, because you know that that's how you get your royalties. Okay, so if you're interested in collecting your royalties, you have to be very vigilant. So if you know that there's a club somewhere that's been playing your music, what, then you go and ask Kosoma, do these people have a license? I heard them, they're playing my music, blah, blah, blah. They check their system. If the person is registered, they tell you, yeah, if the person is registered, that means at the end of the year, when they're distributing royalties, you know, there's a little something for you at the end of the year, because your music is being played in establishments, registered and reputable establishments.
Wow. That's actually such a money hack, especially if your music is always trending Magwalala. I feel like if you really are serious about that kind of stuff, you could make a good buck. But if you are as shocked as me, and this goes to the audience, if you are as shocked as me, and maybe you have some questions for Madalo, feel free to write them in the comment section and I can ask them on your behalf. Or you can raise your hand and then you can come to the floor and ask yourself, ask those questions yourself. We have 17 more minutes remaining, so that's not that much time. But continuing with the conversation, you mentioned royalties, which I feel is one of the biggest ways that copyright earns money for artists. Is there another way that maybe isn't well known that copyright can also generate revenue for artists?
Of course, it's not that you can solely rely on Kosoma. You can easily license out your music to, let's say, a company. A manufacturer wants to have an advert, they want to have a song in that advert. You can also you can also say that, okay, if you want to use my music to promote your products, let's come up with a deal. You draw up a contract and you get money based off of that contract. So it's not necessarily exclusively that Kosoma is the only way. You can approach companies and say, I'm a musician, I'm an artist, I have the copyright to my works, and I want to enter into an agreement with you for purposes of marketing. You can use my music, this is my rate, we can sit down and agree. It will be dependent on what you believe your music is worth. So there's some artists who charge companies much higher. Some artists, they will not charge their companies much money. It will depend on how you value your money. It's your music. It's just a matter of negotiation and how you decide to negotiate your contract.
All right, all right. Another thing that's also come to mind is how Kosoma is, again, correct me if I'm wrong, but I
Mhm.
mean, it's the Copyright Society of Malawi. So in my head, it's operating in Malawi.
Yeah.
So what happens if my work is being played in other countries? Say I'm an artist, my work is being played in South Africa.
Mhm.
Does Kosoma have the legal mandate to demand royalties from, in this case, the South African market? Or is there some sort of collaboration partnership that Kosoma has with South Africa to make sure that even when your work is utilized in all these other countries, you're still getting paid your royalties?
Okay, so I don't know if most or some of you have heard of Capaso. But Capaso is a digital rights licensing agency that's based in South Africa. So they've partnered up with Kosoma so that if your music is being played, let's say in a club in South Africa or whatever, if it's being played outside of Malawi, Kosoma in conjunction with Capaso can help you recover your royalties from international players.
All right. So, to the audience, I don't know what's happening. I'm not a tech baddie, but it seems the chat is off. Correct me if I'm wrong, but on my end, it's showing that the chat is off. If that's the case, then that means that if you have any questions, you have to be asking yourself. You need to raise your hand to ask those questions yourself. If there's anything that you like to say, then this is the time for it. I see a hand from Wangani. Wangani, you can take the floor.
Wangani, you're muted. Wangani, can you hear us? I don't know if it's just me. I can't hear Wangani.
Yeah, me neither, but I can see the mic is on.
Yeah.
If you have earphones on, it's probably that. Uh, Looks like we have a little problem there.
Yeah.
Yeah, but we will still wait in case they fix whatever issues they have going on their end. But moving on, you did mention that there are violations that happen in terms of copyright, like someone can copy your music or certain elements of your songs and things like that.
Hmm.
What does the process of suing that person look like, especially in Malawi?
Okay. So let's say, for example, you hear that somebody is making illegal copies of your CDs, or let's say, for example, you hear a song that is sampling your song and you have not given that person permission, then what you do is you find a lawyer and commence a matter in the High Court of Malawi for the High Court to make a determination on that. So it's a pretty straightforward case. You just start your summons and you sue them, in essence.
Yeah, what do you mean start your summons? Because, okay, for me,
Hmm.
right, as
Yes.
I sit here, you're the only lawyer I know,
Yeah.
right? But there's a chance that there's someone out there who, if they maybe felt like they had been violated in that way, they
Hmm.
literally don't know where to start. It's like, where do I find a lawyer? Where do I get a contact? Is there an office that I can visit? Do I need to pay? How much do I need to pay? You know, things like that. Like,
Okay. All
yeah.
right. So it would depend. Um, you might be able to, there are lawyers who we call legal aid lawyers. But because this is a commercial transaction, because copyright issues are looked at as commercial transaction, you might not be able to get what we call a legal aid lawyer. So what you need to do is locate a lawyer who can help you with your claim. If you don't know how to locate a lawyer, Since lawyers were not allowed to advertise, you can simply go to Malawi Law Society and ask for the register of lawyers and say that I'm looking for a lawyer who can help me. I've got a case. This is my case, and you'll be given a directory and told to choose a lawyer of your choosing. So it is literally just about finding a lawyer who can represent your rights in court.
All right. And then let me gather my thoughts a bit. I know I'm pretty much kind of taking you away from
Yeah.
something that
All
you said.
right.
Wait, what?
No, I said that's all right. You
Oh,
can
okay.
go on.
But yeah, you mentioned that in the framework of IP, there's
Yes.
things like the copyright laws, and then there's the trademarks, the patents, and things of the sort.
Yes.
I would like to focus especially on the trademark parts, because that's something that outside of music, I see it happening a lot. Like recently, there's been a case where, if I'm not mistaken, is it Louis Vuitton has gotten a trademark or patent, one of the two, over a design that traditionally is considered African. It's a tribal African thing. Now, what does that look like in terms of, again, protecting works? But I'm thinking especially in terms of heritage works. How do you protect something that, say, things like Beni, things like Manganje, you use Manganje elements in your song. Is that something that you can actually claim and say that this thing is mine? I'll take an example of Tegrin's music, and I hate to single him out, but he uses a lot of elements that are Nyao. We all know he doesn't own Nyao, but then it's like he uses that in his music. So how do you go around, just protecting your work when huge aspects of your work are tied to culture slash tradition slash heritage that you as a person or a brand or an artist do not necessarily own?
That's a beautiful question. So, what people need to understand is that expressions of our culture, okay, are vested. Like, let's say something that's part of our folklore as Malawians. The copyright in that work or in that cultural expression vests in the government of Malawi for the benefit of the people of Malawi. So foreigners cannot now try and exploit that work, try to make it look like they created that work, because that is a cultural expression that belongs to the people of Malawi. So it would be the government now taking that individual to task.
Does this mean that
So
the
that's when
government
you have
just naturally, no, go
So,
on.
for example, if let's say an international artist, right, wants to use something that is specifically a cultural expression of Malawian folklore, then you have to go to the minister, okay, Minister of Culture, and then ask for specific consent to use that particular thing to get economic benefit. And the minister will be able to negotiate on behalf of Malawians to say that, okay, if you want to use our cultural expression in your works, then you have to pay to the Malawian people the X amount of money, or they will negotiate a contract from there. So those kinds of cultural expressions, if it is uniquely Malawian, if it is a form of Malawian folklore, then it is protected by the government of Malawi. Yeah.
Okay. So Ongani has sent a message. I don't know if the chat is now working, or maybe he has DM'd me, I don't know. But he or she apologized for the technical issue, and they said they want to know how they can track music that is being played in clubs or other places where you as an artist are not present. That's question number one. And they also had another question to say, how are artists compensated for the songs used on social media?
Those are both very, very good questions, Wangani. I'll start with your very first question with how can an artist track what's going on in clubs and whatnot. That is the work of Kosoma. Okay, that is what Kosoma is there for. That's why I keep insisting that as an artist, it is very important to go and register with Kosoma, because once you register with Kosoma, Kosoma is able to track those places for you. Number one, they are able to track to make sure that those places have licenses, and number two, those places are required under their licenses to keep track of the music that they're playing, so that they know which artist to compensate. So if, let's say, they play 30 songs a night and your song is among them, then that venue sends a report to Kosoma and say that this is the music that we played. So from there, that is how your royalties are calculated. So it's very difficult for you as an artist to keep track and say that, oh, my song was played on MBC 5 times, it was played at XYZ club 2 times, it was played by this DJ at this set 5 times. You cannot keep track of that. Kosoma keeps track of that for you. The second question, I believe, was with regards to issues of your music being played on social media, right? So
Yeah.
let's say your song is on YouTube. You have uploaded your song on YouTube. You need to understand that if you upload your music yourself on YouTube, it is very difficult for you to now say that, oh, I want to recover royalties from YouTube. If your channel is not monetized, you're not going to recover your royalties from YouTube. What you need to go through is what is known as a distributor. So you need to enter into an agreement with a distributor. The distributor puts your music on an international platform, and then you'll be able to recover from that distributor. And in the instance of, let's say, for example, you're in a situation where your music is on, let's say, maybe something like TikTok, right? If your music is on TikTok, it has been put on TikTok through a distributor. That's how the importance of being in registered under Kosoma is that Kosoma has an agreement with Capasso. So if Capasso is able to recover from TikTok, then you will also be able to recover from TikTok through Kosoma, through Capasso. So it is a very complicated process. That's why, as an artist, it's important for you to register with Kosoma so that they can handle some of this back end stuff for you.
Thank you so much for that. Wangani, if there's anything else, feel free to write that down. Unfortunately, we have 3 minutes remaining, but I would like to highlight a question that's also come up in the comment section from Hadi Kaduya, which is a very interesting one. He says, still on the topic of intellectual property, but diverting a bit from music, there was a recent online debate about watermarks on photographs. A photographer's client complained that some photographers still leave their watermarks on photos even after the client has paid for them. What does IP law say about this issue?
Okay. So the thing about copyrights is that there are economic rights and then there are moral rights. Okay. So what a moral right is your right to claim authorship. You can say that, okay, there's nobody who can take your moral rights away from you. Let's say, for example, I am working under an employer and I am the one who has composed a particular song or have created a particular work under an employer. Despite the employer owning the economic rights to that work, I own the moral rights to that work to say that I am the one, me as Madalo Banda, I'm the one who has created that work. So I own those rights. It's similar in a photograph, to answer your question. The photographer has the moral right to that work to say that, okay, I have the rights, the copyrights, the moral rights to this work. But what most people also don't understand, and this is something that you need to take into consideration, this is just a good life thing to know, is that if a photographer takes a picture of you, let's say I am a photographer, Thoko, you are my subject, and I take a picture of you, I am the one who owns that copyright, not you, Thoko. Even though you, Thoko, are the one in the picture, the person who takes the picture is the one who owns the copyright to that picture. So just because you go and you buy a copy of that picture from me doesn't mean that now you own the copyright in that work. You have bought a copy of my picture, but doesn't mean you own the copyright to that picture. Unless you and I enter into an agreement to say that I want, when we're entering into an agreement to say that if you take my picture, I will own the copyright in that work. But otherwise, the photographers have every right to put a watermark on those pictures because they are the owners of that copyright, despite the fact that whoever is in those pictures has bought a copy of that picture. The photographers have every right to sell those pictures to whoever they please. So let's say you have a wedding or a birthday party, Thoko, and you decide to say that, oh, I want to get a photographer, a professional photographer, to come take pictures of my birthday party. The photographer comes, he will take pictures of your party. He owns the copyright in that work. You didn't even think about it. You decide, oh, I just want a photographer, I pay him and whatever. That photographer can use your pictures and sell them to anyone he pleases. He can sell them to a company. He can sell them to musicians. He can use your pictures to promote himself. He can put it on a promotional work. The photographer owns the copyright to those pictures. So I think people don't understand the seriousness of intellectual property rights until things go wrong. But the photographer owns it.
I am shooketh. What do you mean they own our pictures? What do you mean?
That's why the paparazzi are able to sell pictures of celebrities, because they are the ones who, and they can, those pictures can then be put in magazines. So if you're a celebrity and I take a picture of you as a celebrity, I can take that picture and post it on in a magazine because that's my picture. I own it. I have the copyright in that picture.
I just feel like it's a human rights, it's a human rights violation. It has to be a human rights violation of sorts. Because what do you mean you can take my picture and sell my likeness to someone else, especially in a situation where I didn't consent? It really does feel like my human rights are being violated in a way. But I don't want to dwell on that. I have personal beef, but I don't want to dwell on that. We are over our time. I don't know if you still have time, Madalo. There's another question in the comments.
I've noticed that there is one more question. I will answer it very briefly. I want to make sure I cover every question.
Okay, so Ambroso says, I'm not clear on the issue of cultural or traditional music. There's a UN Charter on Indigenous rights to self-determination, which I'm told is domesticated in our country as well. Now, if the indigenous people, or indigents, he said, are free to self-determine, why should the government be responsible for the attribution of their knowledge? Like, why should one seek consent from the government and not the people themselves?
Okay, I think to answer your question very briefly, the question was posed in the context of, let's say, a foreigner trying to capitalize off of Malawian cultural expression. Then you would have to seek consent from the government. But as local Malawians yourself, you do not need to seek permission from the government. You are allowed to express yourself in whatever way. You are allowed to develop the folklore. You can create something like, let's say, Beni, right? You can choreograph something in the Beni dance, but it will be your own unique composition. You don't have to seek permission from the government for that. This will come in for, let's say, foreign actors who want to capitalize off of Malawian folklore. So it's the difference between a foreigner and a Malawian themselves. I think that was the context of your question.
All right. I think that's pretty much it, unless there's anyone else remaining. I do not see any hands. I do not see anything else in the comment section. So that tells me that people are quite satisfied with this session that we had. I'd like to thank you so much, Madalo, for making time to share with us today. It has been so informative. It has been so eye-opening, especially with the festive season coming up. If you're there trying to book a photographer, just know you may find yourself in the news and you didn't even give them permission, but apparently they own the right to your likeness in that regard. That has been so eye-opening. Thank you so much, Madalo, for your time today.
You're welcome.
I don't know if there's anything else you'd like to say in closing before I wrap everything up.
Not really. I just wanted to say this has been a fun session. We're going to be having more and more and more sessions as we go along. But this was just an introduction, and I hope you tune in for the upcoming sessions as well.
Yes, thank you so much for reminding me of that. In a previous conversation, just before we got online today, Madalo said she is open and willing and excited to have more sessions like this. So this was an introductory session for intellectual property rights, and then we're going to be talking more about what that looks like. So today was about copyright. We don't know what Madalo will have up next for us in another session. But if you follow us on social media, then you will know when we'll be online and what we will be talking about. But from the Vwaza team, from the Diamond Standard team, this is where we wrap this session up. It has been a session on understanding intellectual property rights. This has been recorded and it will be uploaded on our YouTube channel on Friday. That's the Vwaza Multimedia YouTube channel on Friday. So if you want to revisit this conversation, then it will be up on Friday and you can have whatever time you need to revisit this. Maybe there's something you didn't understand, you want to go back and listen to it, you'll be able to do that. Apart from that, I've been your host. My name is Thoko. Thank you so much for joining us today. This is where we call it a night.
Bye.
Bye.